Good afternoon. I'm Jen Ritter-Tmassett, Marketing Coordinator of Events and Proposals at Borden Smith. Welcome and thank you for joining us for the fourth session of our Community Associations Building Blocks webinar series. This town hall session will give you an opportunity to ask questions related to your associations. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. Throughout the presentation, please type your questions in the Q&A box. Let's get started with speaker introductions. Today's speakers are Adam Bowden and Madeline Light. As leader of the Community Associations practice, Adam advises community association and country club, yacht club boards and members regarding corporate governance, procedural requirements, governing document amendments, fiduciary duties, inspection right, collection issues, and rule adoption and enforcement. He also has experience preparing all components of community association, country club, and yacht club entity formation, including articles of incorporation, bylaws, committee charters, organizational minutes, confidentiality policy, communication policy, and documentation retention policy. Madeline frequently advises community associations and their boards and members regarding the formation of new community associations, corporate governance, procedural requirements, governing document and amendments, fiduciary duties, inspection right, collection issues, and rule adoption and enforcement. I'll turn the mic over to Adam and we can begin.
Thanks, Jen, and thanks to all of you out in virtual land attending today. As Jen said, this is the latest installment of our webinar series and kind of a unique one because it's kind of a what's keeping you up at night, right? Q&A, it's stream of consciousness. And so we invite you to use the chat function to pepper us with some questions. And we'll do our best over this next hour to get through them. And so appreciate that, right? You guys are the cruise director and Jen Ritter is our captain. So we're, I guess, dual first mates, Madeline. I think that's what we'll be called today. So I'm going to kick us off. There were a couple of questions that we received before the session today, which seem appropriate. And so the first one is a question asking, should a planned community open up its common area to allow a healthcare provider to come on property and administer COVID-19 vaccines? And as part of this question, information was provided that the healthcare provider has up-to-date licenses, certificates of insurance, et cetera, et cetera. And so, Madeline, I'm gonna turn that one over to you in terms of what do you think about opening up common areas, in this case, a parking lot or a clubhouse, to administer COVID-19 vaccines exclusively for residents of that particular community?
Okay, well, thanks, Adam, for passing off the first question. Good first mate there. Want to say hello to everyone. I know we haven't met officially, but again, like Adam and Jen said, thanks for being with us today. As far as the question about COVID vaccinations, I think the first place to start is, can the association do this? And then next, should the association do this? So first things first, unless it's expressly prohibited by the association's governing documents that this type of activity couldn't be conducted, and then also assuming that, yes, the coverage for the healthcare provider, the insurance is all up to date and all of that is completely fine, then yes, technically I think the vaccinations could occur on the common area if the board, voted to allow that to happen. However, one of the things that I would caution the board and the association to think about is, okay, if we let these vaccinations happen on our common areas, even if it's just for our residents and even if it's good to go as far as insurance, what else are we opening ourselves up to as far as other liabilities? What if someone, not necessarily a result of the vaccinations, but what if, to take it to an extreme, someone gets a shot, they end up getting in a fight with one of the nurses, with another community member. If anything happens during that, is there going to be some type of recourse against the association? So that would be something to think about, as well as, okay, the purposes of the association is to enforce the governing documents and maintain, repair and replace the common elements. Is giving vaccinations furthering those purposes, or is it outside the scope of what the association should be doing? So I would want a board to think about that and those extra liabilities that could come along with, yes, this is a good purpose, but is it a proper purpose for the association?
Yeah, thank you, Madeline. That's with everything, right? One of the biggest things that the two of us work on together is not only can an association do something, but should they do something, right? And so we typically start at the top of the mountain, which is, hey, what's the purpose of the association? I've never seen an association that had a purpose for the health, safety, and welfare of its members, right? It might exist, but I've not represented that association. And so although I think most folks would agree it's good, it's a good thing to do, you just have to do it with your eyes wide open with most things. And so I'm gonna hit everybody with the next question, which is essentially the question centers around, do you treat say a violation of the rules versus a violation of the declaration versus maybe a violation of the bylaws? Do any of those get treated any differently with regards to the procedural obligations the association has when it comes to enforcement? So I'm going to kind of back up a little bit, right? And so whether you're in a condominium or you're in a planned community, and what we mean by a condominium is either a 47C or a 47A condominium, or you're in a planned community, what we mean by that is a chapter 47F rather, which could be either single family homes, garden homes, it could be a townhome community, but it doesn't really matter. The law in North Carolina is pretty much the same across the board when it comes to how a violation of any of the governing documents must be dealt with. And that is, a notice of violation must be sent to the offender with a hearing to be set, and the institution of fines should not take place until after the hearing. And there's a couple other little nuance to this, right? Like the notice should be no less than 10, no more than 60 days. But you can vary this with your governing documents, but as Madeline and I can tell you, rarely do we see a situation where you can avoid having to send a notice of violation and hold a hearing before you're able to find somebody. We see it every now and again, but it's rare that it will meet the statutory requirements of being able to find somebody without a hearing. The most common place we see it is the towing of vehicles. And I've done several of these amendments where we put where we put in the declaration that you can tow someone without a hearing, right? If somebody parks where they're not supposed to, the association can tow them, and the owner has to pay the money to get it out of hock. And so we're in this process. So can a hearing be held by Zoom? Let's kind of segue that into the answer to this question. We believe that you can. And there is legislation up right now here in North Carolina that would formalize it and make it a definite yes to that. But we have advised our clients that you can hold a hearing via Zoom under the current executive orders that the governor has. I think it's 204 is the one that's good till May the 10th, I believe. The question here, the second part is, can you require the hearing be held by Zoom? You can't require it to be held by Zoom, but keep in mind that the association is the arbiter of the hearing, right? So if the association says the hearing is going to be held by Zoom, that's the way it's going to be held, right? And if the person doesn't have a computer, or they don't have access to the computer, right, then maybe we've done it where hearings are done over the phone. And so any venue where you can simultaneously hear one another. And so I know during COVID times, folks are, some folks are more reticent than others to want to meet in person and make sure that we're not exceeding inside meeting capacities. Some boards are large. Some boards may be over 10 by themselves. And so anyway, when it comes to the hearing, we've been doing them by Zoom all along. So getting back to this point is that if someone violates a covenant, barring a very rare circumstance where there may be a carve out, like for towing a vehicle or something of that nature, you're going to have to hold a hearing before you take any action. And so the way that you handle any violation is going to be consistent with regards to, it doesn't matter how egregious it is, you're going to first send a notice of violation, you're going to hold a hearing. The way that you vary the response is based on the severity, the number of times this person's been an offender, right? And so I'll give you an example. Let's say I build a fence, and I build this fence without permission, but I build this fence the right color, the right material, the right height as provided in the declaration, right? But I just didn't submit an architectural request. Well, you'd send me a notice of violation. And the violation would be, I built something without approval. So then you call me in, and if I'm smart, I'm going to show up with my application, right? And I'm going to submit my application at that hearing. All right, well, then the board has a decision to make. They can be like, oh, this Adam Bowden guy, he's a good one. He's nice to his neighbors, doesn't cause us a lot of trouble. He made a mistake, but he's corrected it. All right, we're going to approve this fence, and we're not going to fine him the $100 we could fine him for failing to submit the architectural request. So we're not going to punish him. We believe that he was trying to do the right thing and he just messed up. Whereas, let's just say Jen Ritter, for example, Jen never follows the rules. She builds planters and all kinds of stuff. She's got a veritable garden going on in her front yard and never gets gazing balls are in there. Like, I mean, she just doesn't follow the rules, right? Every time it's fall, it's happy fall, y'all, on a big flag in her front yard. And you just decide, hey, with someone like that, you might decide, oh, we're going to fine her that $100 because she needs a slap on the wrist because we need to get her to comply. Now, let's just say in this situation, let's kind of change it a little bit, right? And let's say that I build a fence that's not allowed, or let's just say fences are not allowed at all. They're prohibited by the declaration, and I build a fence. Well, that's as the Wizard of Oz would say, that's a horse of a different color, because now I've installed something that I can't get approval for. I've installed something I'm not allowed to have. You're still going to have to send me a notice of violation, and I'm still going to have to come in for the hearing. But unless I've removed that fence prior to the hearing, I'm going to get a fine, and I'm going to get a 5 days grace period to remove that fence. And then after that, it's going to be $100 a day until you remove it, right? So we start the process the same, but the way we end the process might change based on facts and circumstances. The important thing is that we're consistent for the beginning part of it, the beginning procedure. How we end up dealing with the violation, that's customized depending on facts and circumstances, right? And I'm not saying we treat different people differently for the same violation. I'm just saying that every violation is unique to itself after you've had the hearing. Okay, that's what I'm saying. So, all right, so we have a question that came in, and thank you, Candace, for this question. So it says, should the developer board make a change to the responsibility of the HOA, i.e. maintaining lawns after the CCRs have been amended? Does the annual budget need to be updated simultaneously? If so, can the developer board simply make the change, ratify that revised budget and notify the membership of such change. Well, this is kind of an interesting one. And so I'm not going to presume that everyone on this call understands what exactly a developer board is. So I'm going to kind of tease that out a little bit, and then Madeline and I can kind of walk you through the rest of the steps. But so what a developer appointed board basically means is that you have a situation where the developer, through whatever right they've carved out for themselves in the governing document, is appointing the board members or is electing the board members if it's a Class B, Class A type situation. And so I believe the question here is that the covenants say one set of things in terms of how the property is going to be maintained. And now this board is being asked to make some changes that would impact the budget. Okay. And so what I would say is this, and I'll throw this to Madeline, which is, you know, is there ever a set of circumstances where a board could unilaterally amend a declaration or amend the restrictive covenants? So Madeline, I'll let you take that one.
No, under the statute, there's not a way that a board could just unilaterally amend the declaration. That's something that there's a few of those items, that being one of them, amendments to the declaration, that do have to be put to the membership. So especially adding a responsibility for the association. I think one of the examples here was like maintaining the lawns. If that required an amendment, it would need to be put to the membership, as my understanding.
That's right. And it's the same thing with when we talk about budget ratification. What Candace is asking is, and I'm just going to back up again, right? Because in North Carolina, all condominiums, no matter when they were formed, have to have the budget ratified on an annual basis by the membership. What does that mean? That means that you have to present the budget annually, notice it, give a copy of every member, a copy of that proposed budget, and the budget is ratified at that meeting unless a majority or higher number is dictated by the statute or to reject that budget. Okay. It rarely happens. In a planned community or a 47F community, all communities formed on or after January 1, 1999 have to have their budget ratified, right? So the only way that you don't have to have a budget ratified is if you're under developer control and the developer is paying all the expenses for the association, which means you have not yet assessed the members, right? Because that's what the law says. The law says that until you assess the members, the developer has to pay the cost to run the association. But most developers don't like to do that, not shockingly, right? So they will go ahead and get their budget in place. And so any change to the budget is going to have to be ratified. So it seems to me like this is a situation where unless the developer carved out the right to unilaterally amend the declaration, not the board, right? Not the board of developer appointed, board members, right? As Madeline said correctly, they can't unilaterally amend anything other than rules and regulations. They can't amend covenants. So the developer may have carved out the ability to unilaterally amend. However, there's usually a caveat that says you're not allowed to amend as a developer a declaration unilaterally that would change the obligations of the owners or would create more burden on them, right? So if this is a situation where the developer wants to take the burden off the members and put the burden with the association, then it might be able to do it, okay? But the problem is that when you take a burden off the individual owners of cutting their grass and stuff, they're going to have to pay the association more money, right? So that type of amendment, in my opinion, should always go to the membership to figure out what does the membership want. Because if you buy in a, like what we call a patio home community, where there's an expectation that the association is going to maintain my yard looking in a pristine condition, and I don't have to mow my yard, I don't have to buy a weed whacker, I don't have to have a can of gas sitting around, right? And they're going to prune my shrubs and my trees and everything. And all of a sudden, now you're saying, no, we're just going to let the individual owners do it. That's a substantial change. And you're going to have to get at least 67% when it comes to, any changes. And so, yeah, that's, happy to tease that out more if you want, Candace, but that's kind of where we land on that one.
And also, it's not exactly to Candace's point, but Adam, to what you were discussing earlier about instances where an association would not have to have their budget ratified, those pre-47F communities. So the communities created, and that wouldn't occur in this instance with the developer control, but that were created prior to January 1st, 1999, whatever your governing documents say, that's what you do as far as budget ratification. But like Adam said, otherwise, any changes to the budget would need to be ratified and put before the membership.
It's a good distinction. Thank you for putting that in there. Yeah. So again, this is just another area where this is why you want experienced community association counsel to help kind of walk beside you to navigate these situations and kind of get an understanding of what type of community you are. I've got a question on here that, are there any new City of Raleigh regulations on short-term rentals? I'm not aware of any, but let me throw something in the mix here, right? So rentals are in my experience, I've been doing this 20 years, and over the last 5 years, rentals have become a super hot button issue across the country, but big issue in North Carolina, not just here on the coast where I'm located, but up in Raleigh, in Charlotte, Greensboro, and in Asheville as well. Any time that you have people either in a resort type location, right, where it's mountains, it's the beach, or you're in a high metropolitan area where people might invest in buying, condos for rental, for rental income, you're going to have some stress over rentals. And so over the last 5 years, we've seen a big change in that. And that, of course, is, I would just say there's a correlation there with the Airbnb, VRBO, right? These virtual platforms that allow people to rent out all or a portion of their home to what I like to call a transient guest most of the time, right? And so we have communities, they come to us looking to adopt rental restrictions, right? They want to stop the rentals. They want to stop short-term renters. They want to look for these types of, what they call a safeguard or a bumper on their community. And the courts in North Carolina do not care for rental restrictions at all. They will enforce them if they're narrowly tailored and if they were originally in the governing documents. But it is hard to take a community that has allowed rentals without any prohibition on it and flip that upside down successfully. We've done it. You can do it. It's just, it's full of peril, I guess is the best way to put it. So when this question comes in, right, so a lot of communities are looking to their municipalities now to try to help them stop short-term rentals by hoping that they're going to enforce an ordinance, right, or put an ordinance in place. And what I would say is that even if you do have a municipality that puts in some type of restriction on short-term rentals, which the city of Wilmington tried to do it recently and they lost. It went all the way up to the Court of Appeals and they lost the ability to have it valid. It's still the municipality's ability to enforce it. The association doesn't have any ability to enforce that. And I know some of you out there in virtual attendee land are probably saying, well, gosh, Adam, my governing documents that say a violation of any city ordinance or state law is also a violation of the governing documents. Well, in those cases, maybe you do have the ability to find them, but you really, what we have often said, and if you attended one of the earlier webinars that we did, Clint Cockburn and I, we talked about zoning and letting the municipality be the one to enforce their ordinances and not to get in between that. And so that's, you know, that's, so Madeline, I don't know if you have anything you want to add on that, or if you've seen anything new from the city of Raleigh, but I haven't.
I have not seen anything new, especially just in the short-term rentals. I think you pretty much covered all of that.
Yeah, and so, you know, happy to entertain some more questions on rentals. I mean, Madeline and I can talk all day long, and we've got lots of things that we can talk about, but this is your seminar, I guess you'd call it, or this is your opportunity. What's keeping you all up at night? Don't be shy. We've got almost 30 folks on this. I'm sure there's some things that, you know, if you're worried about sending it to the whole group, you can just send it to me and to Madeline. Happy to answer and keep your name off of it. Madeline, maybe talk a little bit. I know that you've been keeping a watchful eye on the legislature in terms of what's coming down the pike when it comes to virtual meetings for members and all that kind of jazz.
Sure. So Adam mentioned it earlier, but there's actually two pending bills before the legislature right now, both that deal with electronic meetings and electronic voting. So as many of you probably are aware, through the governor's recent executive orders for nonprofits, there's been the ability to hold meetings virtually. So this legislation, it passed, and again, it's two competing bills. They're addressing the same thing, so we don't know exactly how it will turn out, but the gist of it is it would take what the governor's executive orders have allowed as far as electronic meetings to be from now until forever, instead of just expiring at the end of one of these periods of the executive order. So it would change Chapter 55, which is the Nonprofit Corporation Act, and like I said, it would allow for meetings of the members to be held virtually, as well as voting to take place virtually. What I think will be interesting, and Adam, we'll have to, you know, sort of brainstorm this, you know, with the community managers and everyone going forward. Okay, so we have the ability, say that this bill passes and is enacted into law, to hold and vote virtually. What does the voting virtually part look like, and how is the best way for associations to vote virtually, make sure that it's done properly, that the right people are voting, quorum, all those things that come along with voting and meetings. That'll be an interesting new topic to tackle. But again, that is pending legislation. And so probably I would say by the end of the month, we'll at least know the next steps on that. So we'll keep all updated.
Looks like Madeline's frozen.
Oh, no.
I don't know, we can't hear you anymore, but that's okay. I'll pick it up from there. Yeah, and so what Madeline has been saying, I think she's back with us, is that there's two pieces of legislation, right? One bill that was started in the House, one in the Senate, and you know, the bill in the Senate, I believe, is a little more what you'd say a little more expansive, I guess, than the one that came out of the House. And so the one that came out of the House was working with Community Association Institute, right? And the Legislative Action Committee for Community Association Institute, which, as Madeline said, was basically born out of the governor's executive orders to allow for these virtual membership meetings, but not really allow for a virtual vote. The voting had to be done via written ballot. And so the Senate bill is going to give lawyers a lot more work to figure out if that one gets approved or they get melded into a new one. in terms of what does electronic voting look like and what types of safeguards you can put into place to ensure that there's no funny business kind of going on. And I'm sure that many of you that are managers out there have enjoyed virtual meetings. I certainly have. My favorite function is the mute button. I'm not sure how many of you could virtually raise your hand. All right, well, it looks like Caitlin. Hey, Caitlin, thanks for coming out. Has a question for us. And it says, if the governing documents prohibit hanging or displaying signs and banners, but do not mention flags, should the membership consider updating the documents to specifically address flags? Owners continue to ask us to instruct renters to remove flags, but the board feels that the docs are too vague to fight the battle. They're also concerned about banning all flags. Will this cause an issue specific to the American flag? Should they get themselves into a mess? If they do, is it safest to ban all no without any exemptions? Or exceptions, not exemptions. So I'm gonna kind of hit this one, and then we can, I'll let you grab the next one, Madeline. So North Carolina is kind of funky when it comes to prohibiting political signs and prohibiting flags. The thing you have to know about flags is that you are not able to prohibit the United States flag or the flag of the state of North Carolina, here in North Carolina. So whatever kind of restrictions that you would want to adopt, the statute basically says, sorry, you can't do that. But if you do want to ban other flags, right, minus the current, and by the way, it's current US flag, current North Carolina flag. I have seen so many versions of the North Carolina flag that have some form of what we call the stars and bars on them. That is not a legitimate North Carolina flag that is exempt from restriction, just so everyone knows, in case anyone was really had an inquiring mind out there. But if you want to ban flags, Caitlin, yes, you need an amendment to the declaration. And you know, there's some technical issues to it in terms of the first page of the amendment has to say in bold text, centered, this flag prohibits and or restricts, excuse me, flags. And what that means is that you can limit people to one flag of North Carolina, one flag of the United States. But yeah, I'll ask you, Madeline, I don't really think signs and banners would cover it technically enough to stop flags. What do you think?
No, I think it needs to be more in line with what you said, and there need to be more specific language in whatever amendment was adopted or proposed for tackling that issue.
So if they care enough about it, right, get with your community association council, they can help craft the appropriate language. In fact, every community that we work on, every new community that Warden Smith does, we ban all flags as much as we can in terms of size and number from Jump Street. And if after turnover from the developer, the owners want to loosen those restrictions by amendment, then have at it. But it just makes it easier and by the way, you can ban political signs in their entirety. There is no right to a political sign in North Carolina the way there is the US flag or the North Carolina state flag. We have an anonymous attendee asking about, have you covered the new case law surrounding unenforceable rules? A unit owner's grass cannot be over 6 inches. We haven't talked about that. But what I would say is this, that in North Carolina, for years now, and what I would say is probably over a decade, the courts in North Carolina will not support an arbitrary enforcement of a rule. And what I mean by that is the first case in this line of cases was out at Land's End of Emerald Isle, and which is in Emerald Isle, obviously. And the covenant said that the association, you know, had the power to make sure that every yard was kept in a clean and tidy fashion, basically. And the board interpreted that to mean that they could set rules and standards about what that meant of, you know, clean and tidy and et cetera. And they did put a prohibition in there when it came to like the height of grass and some other things like that, and the court struck it down. And it said that that was void for vagueness. And so there have been a lot of cases like that, not to mention 6 inches of grass, right? Like if the declaration says you can't have your grass more than 6 inches, right, in height or things of that nature, you're okay. But for the board to basically create a standard, whatever that standard is likely not going to be enforceable. And that's like with any rule, that's not just a landscaping rule, but like clean and sightly, clean and tidy, whatever, shall be maintained reasonably well. Like I've seen that before. You just have to have reasonable rules. And so anyway, Madeline, do you want to chime in on anything on that when it comes to those landscaping rules?
Sure, and I think from a community manager perspective, you know, whenever, because, you know, you guys may be some of the first stop for these types of questions before it may get to us. And so I think some of the things like Adam's talking about is when you're looking at these rules that have been promulgated by the board and aren't necessarily in the declaration, when you're thinking about what's vague and what sort of putting on your, you know, your judge gown for a moment, one definition of one word, you know, if you could put it to 5 people and have them describe what it is, and everybody's going to have a different answer, the language in that rule is probably going to be viewed the same way by the community association lawyer or the judge who's looking at it. And I think that's where it can be really important to look at, okay, whatever rules have been promulgated by the board, are those consistent with what's in the declaration? And I think where a lot of boards run into problems is where the rules that they've made, yes, they're in line somewhat with the declaration, but it's given way more power. To use Adam's point, it's set a standard that's higher than what the declaration says. So I think that's important to keep in mind, you know, when those questions are coming to you all and then ultimately to us.
Yeah, just remember that yes, all boards have the right to adopt reasonable rules and regulations regarding the use of the common area. We're not talking about common area right now, right? What we're talking about is rules and regulations regarding a lot or a unit. And so the law is pretty stringent when it comes to a board's unilateral right to tell someone what they can and can't do with their property. It's one thing to have a set of covenants in place prior to the person buying the property, knowing what they can and can't do with it, right? Like saying, hey, I'm not allowed to have a basketball goal in my yard, right? Versus nothing in the declaration about basketball goals. And then the board of directors decides, well, we really don't like kids. And even though this isn't a 55 and over community, we don't want a bunch of people bouncing basketballs around here. So we're just going to ban basketball goals via rule. Well, that, as they say, that dog's not going to hunt. Okay. And so that's the type of thing that you're going to have to ease off on. Otherwise you're going to lose it. And there's a lot of cases where the ability to adopt rules and things of that nature were struck down by a court in North Carolina. Because in North Carolina, we're what's called a blue line state, which means that a judge or a court can take their blue pen and they can strike through language in your governing documents, but they will not add any language, right? They'll just take away. And so you really need to be careful. The nuisance clause is another really great example of a clause that gets abused, right? It's considered, oh, this is the catch-all. The courts for the last decade have been killing nuisance clauses left and right. So you got to be careful when you're using it. It really better be what we call a community nuisance, not just an owner versus owner nuisance type thing. And we've seen it with grass where the height of grass, oh, it's a nuisance if it's above a certain height. Yeah, you're going to lose that one pretty much all the time. Candace is on fire today, by the way. So she has another question. Homeowners are requesting that the HOA's fitness center be reopened. The HOA does not have the financial means to support the costs associated with the required recommended frequent professional cleaning. How can the HOA express that they're not going to reopen the fitness center until the risk of COVID has subsided, such that members would put away their pitchforks and torches? Madeline, you want to take a stab at this, since we have walked on this journey on fitness for about your entire career here with me at Warden Smith.
Sure. And Candace, I love the visual of the pitchforks and torches. I can, when people want to get their workout on, they're pretty adamant about it. Which I can't say the same because I avoid sweating at all costs, but that is what it is. So here, if, and Adam, maybe you'll have a different interpretation, but if for the association, they don't have the financial means to do the professional cleaning, which is still part of the protocols under the governor's executive orders and the CDC orders, is still cleaning, just like face masks, even with these increased occupancy limits. If they don't have the financial resources to have that happen, then I think it is appropriate to keep the fitness center closed until that time, when that's no longer required. I think expressing that to the membership, how you go about doing that could sort of help, ease the pitchforks and the torches, whether that's through an announcement to the membership, or it's just a full stop. The board of directors, as operates under the business judgment rule. So if in the best interest, if we're talking about a 47F community, in the interest of the association, that's where those duties run, is to the association. If it's not in the best interest of the association to open up the fitness center, based on the information that the board of directors have at the time that they're making that decision, then that would seem to be an appropriate decision.
Right. The only thing I can say to you, Candace, that Madeline didn't say is possibly figure out what the cost would be. The additional cost would be to get the staff and the cleaning materials and everything that you would need, right, to check people in, check people out, make sure the occupancy requirements aren't violated, make sure everybody's wearing a mask and that they're kicked out if they're not, all that kind of fun stuff, and put a price tag on it, and basically put it to the membership and just let them know, like, okay, if you want your fitness center open right now, it's going to cost you an extra $50 a month each, or something to that nature, right? Quantify it so that they can understand that, hey, we've checked with legal counsel, this is what the experts say is required. And so it's up to you. If you want to pay this, we're glad to open it, but we're not going to do it on your current budget. So sometimes that can work out. That can work out really well. So see, Henny's got a good question for us here. So he says, one of my 80-member townhome communities on the ocean has plus or minus 7 permanent owner residents and 4 long-term rental units. The rest are second homes and short-term rentals. And there has a few owners that want the board to stop Airbnb type rentals, right? These short-term rentals, and adopt something that, is 7 or more days. Where do we start to get this done? Get this done if the covenants specifically allow rentals, but no time period. So, oh yes, the rental restrictions. Well, here's the challenge, right? If you have a set of covenants that does not limit or prohibit rentals at all, and you're trying to get one in, number one, you have to amend the declaration to do it. That's number one. So it's a minimum 67% of everyone. But even if you are successful, and in a case like this, especially a beach community, right? And I know where you are, Henny, out in the Outer Banks, right? In a community where people are used to doing this, and you said 80, and maybe let's just say that, 70 of them are rented. Number one, it'll never pass because those owners are never going to approve a restriction on their use. But even if it miraculously somehow would pass, there's enough people renting or using as second homes that they would likely challenge that amendment as being what we call unreasonable and inconsistent with the original governing documents. And so I think the likelihood of a court striking down any amendment like that would require a minimum of a 7-day rental, I think you're going to lose on that one. Now, that's not to say there aren't some rental restrictions that you could try to adopt, but they're not going to solve the problems right now. And so, and what I mean by that as an example is adopting an amendment that only applies to owners that take title after the amendment goes into place, or that only those members that vote in favor of it have their property restricted. There's a lot of different things. Happy to talk to you offline about it. I do see where, and so I guess this is in response, this is from Carol, in response saying, the owners are simply going to say that's why they're paying for in their assessment fees. And what we're trying to say to them is, that's right. Your assessments do pay to maintain, repair, and replace the common area. But for an unattended gym that was contemplated as a small, what I'd say 900 square foot or less type gym that's unattended, where folks have key card access either through the clubhouse or separately, for an entrance on the clubhouse, that it's not contemplated that you would have to have it monitored, right? Or put the security measures in. That's not in the budget, right? So you don't get the same level of service without having to pay more money. It's no different than saying we want a lifeguard at the pool now, but we don't want to pay any more in assessments, right, to have a lifeguard at the pool. Those two things don't exist together, okay? So it's about educating your membership about what their money goes to and that there is no extra, right? And so that if you want to hire additional people or you have to hire additional supplies, it's going to cost you. And this is what it's going to be. So they can get mad and they can kick and scream about it, but at the end of the day, every single member is entitled to see the financial situation of the community. And so you can show them where their dollars go. They may not like where the dollars go, but I mean, that's just ignorance, quite honestly. Like if that's what they're going to say, well, I pay the assessments, but also remember this, say I don't swim and say I don't have any family members that swim. I still have to pay to maintain the pool, even though I don't use it, right? And so that's no argument to say that, well, I already pay that, so the gym should be open. So anyway, that's kind of one of those things that irritates me sometimes about the members. And you as managers just have to try to help them explain and say, look, it's not budgeted. We didn't budget for the types of things we had to do for COVID. If you want to, it's going to cost you X dollars more a month. And if you're happy to do that, then let's go ahead and rock and roll. So anyway, got another question here. Should HOAs allow outside guests for the pool season? If they do, can we require the guests to show their vaccination card? Madeline, what are your thoughts about this one? Just in general, what is kind of your off the cuff thought about should outside guests be allowed for pool season? And can you require guests to show their vaccination card?
Well, for the guest part, under Governor's most recent executive order 204, outdoor pools are now at 100% maximum occupancy. Still have to try and maintain the 6 feet. But again, if you're in an outdoor pool, you're now at 100%. If you have an indoor pool, you're at 75%. That's the occupancy limit. So if you're just going off that, just what the executive order says, in the regards of occupancy, if allowing members or residents as well as guests, if you had some type of like sign up or here's time slots where you all can go, that includes your guests, that you could do it then. Now, whether that's the best decision, that could be, something else to think about. But I think is from a purely can you allow guests, I think if you stay within the occupancy limits for the indoor, now that we're at 100 for outdoor, I think that's okay.
Yeah, and I mean, in terms of asking people to show proof of a vaccination card, my first question is why? And I say that as smug as possible because remember, it's not the association's job to prevent people from getting COVID. It's not the association's job to make sure that people who use the pool have been vaccinated, nor people that use the fitness center. What the association's job is to follow the governor's orders when it comes to being able to show that they complied with state law. Now, as a result of following state law, hopefully the spread of COVID is suppressed or slowed, right? By standing 6 feet apart, wearing a face mask, and washing your hands, right? The 3 W's. But the association is under no obligation to make sure that people are vaccinated prior to using their facilities. And I quite honestly don't think it would be legal to do anyway, because you're not really legally able to ask someone that is an association, have they been vaccinated or not? I mean, that's confidential information that they don't have to share with you. They can share it with a healthcare provider. But until the law changes, and it may, I think, I think that they may, that may happen eventually, but that's not the association's job. Just remember that. It's compliance with the governor's orders. And so we've got a question here that says, if the HOA desires, do they have to go back to 100%? Well, I think that's a harder question to explain why you're not back at 100% versus why you haven't opened up your gym, right? At 75% or at some other number, right? Because if you can open at 100%, the pool's always had more lenient rules than a fitness center or indoor meeting hall anyway, right? So what would be the reason, what would you tell your membership as to why we're not at 100%? When your job is not to make sure that everybody who uses the pool is COVID free, right? Your job, so the only way to keep down the occupancy would be is if you don't have the protocols in place to follow the other steps, right? That are required. And so what do you think, Madeline? I mean, that's which side of that argument do you want to be on? The one that, hey, we're not going to open 100% capacity, or we are? What do you think?
I think if you're at the 100% and then you're saying, no, we're not going to open, I think you're really opening yourself up to go back to what we were talking about earlier, the pitchforks and torches. I mean, people love their pools. But I mean, to Adam's point about, okay, if you have an association where, yes, they could open to 100%, but if you had 100% there, or even close to it, you couldn't maintain those other safety protocols. Specifically, the one that would come to mind for me is whenever people are on the pool deck, can you keep them 6 feet apart? If you can't do that, I think you would have more justification for saying, no, we're not going to open up all the way to 100% because our space is too small, the pool deck is too small. It wouldn't allow for people who aren't in immediate, family to be further, to be the required 6 feet apart, which could cause an issue. And I think is justifiable if you did have someone who was pushing back on you. That would be a response that they wouldn't really have another answer to. So.
Yeah, that's right. And thanks, Cheryl, for adding that in there. Well, Madeline was answering that because, right, so if you can't maintain 6 feet apart for same household guests or whatever, then what are you going to do? Are you going to force people to wear face masks, right? I mean, there's all different kinds of things that you'd have to do to show that we're being compliant. And remember this, everybody, right? I know I've said this, and I probably may be taking it for granted because we're all probably a little fatigued from COVID right now. And we're about to go through another pool season with COVID where actually we were delayed, right, in terms of opening. Our job as lawyers is to mitigate risk for you. for your communities, right? Our clients are the association. So what we're trying to do is, in the event something bad happens, we want the association to be in its best position to defend that something bad, i.e. a lawsuit, right? And so everything, the advice that we've provided and other attorneys and CAI throughout the state have provided is, how can you show that if someone gets COVID and gets sick at your facility, that you did everything in compliance with the governor's order to prevent that from happening, so that it wasn't your fault, right? You weren't negligent. You followed the statute. You were doing the right things, and it still happened anyway, right? And so that's where our head is at. So if you can't reopen your facility, whether it be pool, fitness center, whatever, in compliance with the governor's orders, then you shouldn't reopen. And that's not me trying to be mean. It's not me trying to get you as managers in hot water. But the reality is, there is no insurance for someone getting COVID at your facility. And if they show that you weren't following the governor's orders, they win. And there's no insurance for it. There's no defense. There's no insurance defense. There's no insurance money to pay that person. So if someone gets sick, someone dies, you weren't following procedures, your members are going to be who wanted to be cheap and didn't want to pay extra to have attendance and didn't want to pay extra for the good cleaning supplies and all that. Well, guess what? They're all going to get assessed that $1 million or a couple $1 million in a wrongful death lawsuit or something like that. That's going to be far worse than anything else. And yes, that is an extreme example, but that's what we deal with. That's why we have drop jobs, because bad stuff happens all the time. We don't want that to happen to you guys. So we've got about 3 minutes left. Does anybody else have a question, whether on these topics, anything else that's keeping you up at night? Give it about a minute here, and if not, see how fast your little fingers can type. If not, we'll get Jen to close us out, and we really appreciate folks attending, and we'll see you again real soon, and hopefully we'll see you out at the pool. We got one. It looks like we got one. Oh, no, that's just Candace saying thanks. You're welcome, Candace, and thank you for all your awesome questions from a variety of subjects. So we really appreciate it.
Yes, thank you.
Great. Well, thank you so much, Adam and Madeline. For those of you in attendance following the webinar, you'll be sent an email with a list of articles related to the issues discussed today, a recording of the session, and a link to sign up for our community associations alerts. We appreciate you taking your time out of your day to join us. We hope you're able to take some of the information you learned today and apply it to your own associations. Thank you again, and that concludes today's webinar.
Thank you, everyone. Enjoy.